Okay, good afternoon. Welcome to the Thurston County Board of County Commissioners meeting for Wednesday, April 16, 2025. It is 1:04 p.m. My name is Ty Menser, Chair of the Board. We have Commissioner Carolina Mejia to my right, Commissioner Rachel Grant to my left, and Commissioner Emily Klaus. Commissioner Fournier, since the topic today is a land use appeal that he has recused himself from, that's why he's not present. And that is the sole topic, really, of the items on today's agenda. Public virtual attendance is available on the Thurston County YouTube channel, and written public comment may be received up to 2 hours in advance of the meeting and will be distributed to the Board of County Commissioners. Action may be taken at this meeting. So first up is appeal of a hearing examiner's decision, the Wendler case. It's a quasi-judicial hearing, so we will turn to that. And so good afternoon. Again, my name is Ty Menser. I'm the Chair of the Board of County Commissioners. I will be presiding over today's appeal. And again, for the record, Commissioner Carolina Mejia seated to my right, Commissioners Rachel Grant and Emily Klaus to my left, and Commissioner Wayne Fournier has recused himself from this proceeding. The date is April 16, 2025, and the time is 1:05 p.m. The Board of County Commissioners is now on the record in an appeal of the hearing examiner's decision dated January 5th, 2025. Filed by Paul Wendler. The hearing examiner's decision denied the request for a special use permit to authorize an unspecified number of events per year as a temporary use event center at 1120 143rd Avenue Southeast, Tenino, Washington, or the property, as it will be referred to. In summary, the issues before the Board of County Commissioners today are, number one, whether the use at the property is consistent with the county's comprehensive plan. Number two, whether zoning requirements are met regarding the number of events that may be held at the property, specifically relating to parking, landscaping, and impervious surface conditions. Number three, whether sanitary code requirements are met. And number four, whether conditions of approval can be appropriately imposed to ensure compliance. Because this is a quasi-judicial appeal, the board is subject to the appearance of fairness doctrine codified in Chapter 4236 of RCW. Under this doctrine, board members are not authorized to have ex parte communications with the parties after an appeal has been filed with the board. However, if there have been ex parte communications since the appeal was filed, or communication or relationships with any of the parties that may appear to impact their impartiality, then the substance of that communication or relationship needs to be disclosed. In addition, each board member must be able to impartially judge this case on the facts contained in the record and the applicable law. At this time, I will ask each commissioner to make a declaration for the record. And I will begin with Commissioner Klaus.
Thank you. Since the appeal was filed on February 14th, 2025, I have not had any ex parte communications with any of the parties to this appeal. And I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
All right. Since the appeal was filed on February 14th, 2025, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Since the appeal was filed on February 14th, 2025, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Since the appeal was filed on February 14th, 2025, I have not had any ex parte communications with any of the parties to this appeal, and I affirm that I can fairly and impartially judge this case on the facts in the record and applicable law.
Thank you, Commissioners. Do any of the parties have any objection or challenges for any board member to decide this case? Okay, seeing shaking of heads. Thank you. Okay, so now oral argument. The appellant has an opportunity to present 15 minutes of oral argument. Oral argument may not present new information or evidence, but must be limited to the evidence in the record and the specific issues raised in the appellant's appeal. I understand the department will not be presenting oral argument, but is available to answer any questions from the board. The board, if it has any questions, will ask them during or after argument. Any questions before we begin oral argument? Okay. Hearing is now open, and I would call the appellant or counsel to forward for 15 minutes of presentation. good to go.
Great. Good afternoon. Thank you, commissioners and board members. My name is Joe Rayberger. I'm an attorney here in Olympia with Cascadia Law Group. I'm here on behalf of Mr. Wendler and Hillside Farms. We would ask the board to reverse the hearing examiner's decision and approve the special use permit. We would also, as we set forth in our briefing, invite the board to review the conditions of approval, which staff recommended. We included these as Appendix A to our appeal, and to resolve any ambiguities that might have been existing in the record below. We've actually proposed some additional considerations or for additional conditions that the board could consider. Very briefly, Mr. Wendler is a property owner and a small business owner here in Thurston County. He's owned the property that's now being operated as a lavender farm for the past 10 years, since 2015. And as Hillside Farms has operated and through this permitting process seeks authorization to continue to operate it to host special events. There's been a large community demand for this. It's consistent with and supported by the comprehensive plan. These include weddings, special events, and community gatherings, some free to the public, some weddings, etc. He's taken significant improvements, as you'll see in the staff report, to his property, including landscaping, parking, ADA compliance, handicap parking, most recently receiving his certificate of occupancy from the county, confirming all such site criteria have been met. This agritourism that's going on, it's not just allowable, but it's encouraged by and in fulfillment of the county's own adopted comprehensive plan. Despite having met all the applicable zoning criteria under the rural residential 1 to 5, meeting all the site criteria, having received departmental recommendation of approval from Public Works and Environmental Health, and with staff concurrence that this proposal was approvable as conditioned or with conditions, simply an outright denial is entirely inappropriate here, and we believe is gross error by the examiner. As the board knows, its review here is de novo, so we believe it can now reverse that decision and affirm the approval of the special use permit. In the few minutes I have here, I'm going to address four topics, but please feel free to ask any questions as I go along. First is code compliance and conformance with the comprehensive plan. Second, again, we'll be reinforcing the departmental concurrence of your own staff. 3, why the issues below do not support denial, touching on a few of the specific issues, and if time permits, inconsistent application by the hearing examiner with respect to similarly situated applicants. First, code compliance in the comprehensive plan. The property is zoned rural residential 1 to 5. It's set out in 2090A. I don't think there's any dispute that the proposed site configuration meets all zoning criteria as far as setback, site configuration, etc. Pursuant to Chapter 2054, in the rural residential 1 to 5, temporary uses such as special events categorized as temporary uses, including community events and personal social events, which include by your code, listing as examples weddings, private parties, and similar activities are allowed as a temporary use. As staff have confirmed in their staff report, there's no numerical limitation on the number of those, but it's an allowed special use within the zoning code. Applicants need to be able to rely on what's authorized and not authorized in the code in order to plan their businesses, borrow money, invest in these types of businesses. Mr. Wendler did all those things. I'll also make a note that under 2054-070, the future compliance, so you'll see a lot in the record about individual neighbors interested in whether there will be future compliance at the site. Well, the temporary use code provision specifically says that it's subject to enforcement by CPED up to and including permit revocation. The county has a robust compliance unit, and there's no reason to think that that shouldn't be relied on it to ensure compliance. But what should not happen is outright denial in the upfront. Addressing the comprehensive plan for the rural land use designation, which this property sits, the overriding objective is to, quote, provide a balance between human uses and the natural environment in rural areas. This is on 239. That balance is afforded when you attach conditions to activities. That's where the balance is struck in. policy 14, under the rural land use, special uses that may be permitted in the rural area should be constrained in size and scale to maintain the rural character. Again, that's where conditions come in. And that's why I would encourage you to also look at the other special use applications that have been approved by the county that are arguably larger in scope than this one and in more densely populated areas and on smaller rural roads. Rural land use also incorporates Section 8, which is the economic development standard. Again, this is at 814 through 815. The plan recognizes tourism and the visitor industry as an important component of the local economy, that the rural economy is a key contributor, and quote, Thurston County is well suited for this intimate agritourism experience on small farms. So here we've got a type of activity and use that's allowed in the zoning designation and frankly is specifically encouraged by the comprehensive plan. Under policy 3 of the economic development, the county will, quote, provide for certainty and consistency and timely processing of land use permits. Again, when you look at other similarly situated applicants, I don't think that consistency was fulfilled here. And then under objective B, facilitate agritourism through streamlined permitting, reduction of regulatory barriers, and hands-on help from the county staff. And I think what the record shows here is a consistent effort by Mr. Wendler to work cooperatively with county staff to obtain all necessary permits, and in doing so had obtained, concurrence from all the departments that this could be approved as conditioned. Finally, under policy 9, objective D, the comprehensive plan provides that in rural areas, the county should, quote, encourage priority business activities, again, specifically including agritourism and tourism. This is the type of business that the county's comprehensive plan contemplates and wants to encourage in these areas. Second point, county departmental review, and I'll go through these very quickly. Environmental health reviewed this. This may go to your Chair Mesner introduction about septic and compliance. Environmental health reviewed, found the proposal meets the requirement of county code and recommended approval of conditions. All the recommended conditions by environmental health were included in what was proposed by CPED. Public Works reviewed and again, quote, was recommending approval, again, suggesting only imposition of conditions. Those conditions, again, were all included in CPED's recommendation. CPED and planning, I'd encourage the board to review the staff report, and particularly the staff report, supplemental report that was submitted on reconsideration. Again, the CPED included all departmental recommended conditions, ultimately recommended 27 discrete conditions to be put on this to ensure compliance. And again, on reconsideration, in this reconsideration memo, confirmed that as to each and every one of the issues raised by the examiner, those issues were addressed or can be addressed through approvable conditions. Again, this is not a case where outright denial is appropriate. This is a case where this should be approved with conditions. And again, to my point I made earlier, the county maintains a robust code enforcement provision. So in 2054-070, 41.5D, Roman numeral 4. So this is strictly speaking, under the special use temporary uses. The permit can be revoked. If CPED comes finds non-compliance, the permit is revocable. But that shouldn't lead to a denial on the upfront. Briefly addressing the specific issues that were raised below. With respect to the number of events. So I don't know that maybe there wasn't necessarily a number of events listed on the application materials. And I think in staff's materials, you'll note that there's no strict limitation in county code as to the number of events. But the number of events could be something, in this case, which is self-limiting by the site or is a self-limiting condition that the applicant proposed. And in this case, there is a self-limiting site characteristics that the number of events on site would be limited to 56. And curiously why the examiner decided to ignore that discussion at the hearing below, but the applicant agreed to that number at the hearing below and would agree to it here. And you'll note in our appendix A that we include a proposed condition as to the number of events, limiting them to 56. With respect to parking, again, the examiner curiously found issues with parking. I would encourage you really to compare this issue to the Capital City Barnes case and the Edmonds case where the examiner found sufficient that the property owner, quote, may consider encouraging people to carpool. And compare that against the facts here where Mr. Wendler has been using an auxiliary parking with the permission of a neighboring business, actually secured and submitted to the examiner evidence of an agreement supporting the same, and county staff has all concurred that the parking on site is adequate for the number of guests and supplementary that he has secured additional in the event that that ever needs to be exceeded. But the county code criteria has been met. Landscaping, again, the examiner purported as one of her bases to conclude that landscaping was insufficient. Again, we would argue this too is an error. I would note again the staff supplemental report on reconsideration where on page 1, staff confirmed landscaping proposed with the application met standards for perimeter width, and staff determined that there is adequate space for required landscape parking islands and could be provided. There is, and we submitted this as a declaration in our supplemental brief, there is a landscaping plan that was developed and was filed with the county. It's in the county's permitting records. I think there hasn't been any indication that this cannot be approved with that landscaping plan. And I think that can't be faulted to the applicant. If there is a condition, which I think is already in there proposed by staff, that the prior to operations or approval of the permit, that the applicant will submit a revised landscaping plan for the county's approval that meets all county code criteria. That's a very common acceptable land use practice to condition approval based on some submission of subsequent plans. So again, that criteria as confirmed by staff has been met or can be met through a condition. Noise and operational limitations on hours. There is an existing conditions very similar to what the counties impose elsewhere, requiring conformance with all county code and state noise requirements. We proposed an additional condition to limit the hours of operation to shut off at 10 p.m. And we actually have proposed a condition for consideration to install a permanent fixed decibel reading to ensure compliance is being met and monitored. But there's no question that the business can operate and that can be conditioned based on meeting existing criteria, which is how the county has approved other applications. But here we've gone above and beyond in trying to establish that. I would encourage you to take a look at the Capital City Barn case. I think that it's striking. I think we pointed this out in our briefing, the dissimilar approach the examiner took in that case with here, the allowances given to the property owner there. I will note that that one actually involves more requested dates than what's being requested here. They can have up to 60 event days at that location. They can have a higher population of attendees, 150 compared to 120. And that the level of detail in some of their application materials was actually less, when you look at things like parking, was less than what was submitted here. And the neighbor complaints were substantially similar here. So I would encourage you to take a look at those. In conclusion, Mr. Wendler has reasonably relied on, worked diligently to develop a business here in Thurston County, one that's, frankly thriving, but that this jeopardizes and really questions and calls into question his ability to maintain his livelihood out there. It's these types of businesses that allow small farms and small agricultural properties to thrive. They bring tourism dollars to Thurston County. That's what the comprehensive plan is designed for. Outright denial of his application here was wholly unwarranted. I've communicated with the county, or have attempted to. We would be willing to work with county staff or the county on appropriate conditions if the board doesn't think it's prepared to accept the ones that we've provided. And we'd stand ready to do that. Our preference is to do that rather than continuing to litigate this case. But Mr. Wendler's livelihood and farm is on the line in trying to get this approved. So we'd implore you to reverse the examiner's decision, approve the special use permit, and The Appendix A, which we provided, incorporates all of staff's conditions from the staff report and then addresses any issues that we were able to readily identify that might be raised below. Thank you.
Sir, questions from? I had a question for you. So the hearing examiner had a rule in part of her ruling said the scale of the proposal is inconsistent with the concept of a temporary use, as events would occur multiple times per week for a substantial portion of the year, if not year-round. So I kind of a two-part question about that. One is, legally speaking, what would you say the significance of the temporary use prong or determination, or where, what does that mean in terms of the legal analysis? And then from a factual standpoint, would you say that, what's the limit to that? I mean, is the hearing examiner right that each event is temporary, but when you string them together and the scale of what's proposed over the course of a year, is that relevant in your mind, or is that, or you're on the other side of that line? There's a line and you're on the other side of it, or how does that fit in this case from your perspective?
Yeah, thank you. So I think it is temporary. I think it's appropriate, at least, and that's, maybe it's not the most clearly written code provision under the county's code, but I won't take issue with that here. But I do think it is a temporary use, and that we're not creating a permanent building, a facility that's going to work 365 days a year, 7 days a week, as a dance hall or a tavern or a bar or a school, right? It's hosting different, discrete, special events on a singular piece of property, in which case is also associated with an ongoing farm activity. So we're having this temporary use as a special use allowance attendant to our existing farm activity. As to whether it exceeds the scope of it, I find that really curious in light of the fact that they approved 60 event days at Capital City Barns and are now saying, hey, but this one feels like we shouldn't be doing temporary uses. Well, I think that would be a dramatic departure from the county code. And so, it's really critical that property owners, when they're investing and working towards a permit application, that they can rely on some degree of consistency on what the rules are under the county and how the county applies those rules. And if the county is going to adopt differing standards for that, they should do that through code amendments so folks can know what they can plan for. But as you'll see in staff's report, staff confirms that there's no numerical limit based on that. So I think it's a function. Maybe there's a little gray area there, but it's a function of it's a temporary use. It's not a consistent year-round operating business like a tavern or a school or whatever that might be. But there isn't a limitation. And addressing the facts of this case, I think that's why maybe the examiner got a little bit confused early on in saying that this is requesting an unlimited number of temporary uses, which conceivably could allow for a special event 365 days a year. But that is not what's being requested here. That's not what the facts in the record show. Mr. Wendler conceded to and accepted a self-imposed limitation of 56 days per year. It's clearly fits within the code. That's what that condition can be clearly articulated in the findings, that it's limited to 56, and we proposed that. And so I think that's where you find that balance.
Thank you. Any other questions from that question? Okay, good to go. Thank you.
Thank you.
And so thank you, everyone, for being here. The board will issue a written decision on or before, and I'm looking to Mr. Cushing to give me that date from our prosecuting attorney's office. You're muted, Scott. Can't hear you.
Excuse me, I missed what you said.
I was saying that the written decision, is it 30 days we have or 2 weeks? I can't remember the.
Well, it would be, the decision needs to be issued typically a week after the hearing.
Week after the hearing.
That's what it says in our code. So 53 days to have the hearing, and then the 60th day would be the issuance of the opinion. But in this case, since we continued it out, It'll be
23rd
whatever
of
week from
April.
today is, or a few days from, 4 days from now. I think I gave it to Amy, and I can't remember what it was, exact date.
April 23rd. Thank you so much.
There we go.
All right. At this juncture, the board is going to go into a closed session to review under RDCW 4230-142, that portion of a meeting of a quasi judicial body which relates to a quasi judicial matter between named parties, specifically the hearing examiner decision appeal that we just heard argument on. We're guesstimating 30 minutes. That could be extended. So with it being 1:31, we would ask to clear the room, and the board will be in closed session until 2:01. At that point, there may be an extension, or there may be back to open session. I don't know that anything of consequence will happen in the open sessions. If you're waiting around, you're certainly welcome to, but once we come out of closed session, we're, I believe, just going to be closing the meeting. So that's kind of it for the open portion of this appeal. Thank you.
Thank you.
Good afternoon. We're out of the closed session. It's 2:11 p.m. We had one extension there. There's no formal action being taken by the board this afternoon. We gave direction to staff, and there will be issued with honor before the 23rd of April. So we're adjourned.
Meeting's still 7:00 tonight.
I always gotta make sure I tell people thank you for their hard work.
I got a nice little kudos today. It felt really good. Got a little card that said thank you.
Well, you know,